Good morning to you all. My subject is law's empire, its rise and perhaps its fall. Here's my confession. I'm an attorney. So let me begin with a true story from my practice. 20 years ago, more or less, I took a call from a young man who was a reporter employed by our local TV station. I don't think it was the guy who didn't know what a carrot was, but it was someone similar. This young man was disgruntled. The Vikings had just lost an important game, and the defeat was humiliating. And the young man, the sports reporter, told me that the TV station owned season tickets. The Vikings coach had given some interviews during the preseason period and had said the team would do well and that it would qualify for the Super Bowl. Alas, those prognostications turned out to be false. And so the reporter wanted to engage my services as a lawyer. My assignment was to sue the Vikings football franchise in district court, alleging negligence in the performance of football duties, breaches of contracts with fans, and breaches of warranties of sporting excellence. Now, I thought that this guy was joking. No, he assured me. The TV station was behind the idea. It would pay fees, and in fact, they wanted to have a weekly segment following the progress of their lawsuit. He was dead serious. Why can't we sue them, he asked me. After all, it seems you can sue anyone for anything. Now, I tell this story to make a point. In the past 30 or 40 years, the domain of the law has vastly expanded. Law and legal remedies are now perceived as a kind of universal panacea, a universal antidote for all social ills. If your local football team isn't performing up to your expectations, then sue them for money damages. Or better yet, get an injunction against them requiring that they cease and desist from losing important games. So the slippery tentacles of statute and court extend into all walks of life. This is what I term law's empire, and I submit to you that it is a relatively recent development. The meaning of law's imperial expansion is the subject of this talk. Here I offer neither suggestions nor criticisms. My intent is primarily diagnostic. Empires are dynamic things. They expand, they invade, they colonize. Recourse to the courts now solves or worsens, according to your perspective, problems that no one would have thought to have been of legal character 40 years ago. How has this happened? Well, let's look at some examples to guide us. When I graduated from law school in 1979, there was no such thing as wrongful termination from employment. If your boss fired you, tough luck. Civil rights in the workplace dates from about 1974 when the statutes were enacted. Before about 1985, no one had heard of such concepts as sexual discrimination or gender discrimination or sexual harassment. The law didn't protect disabled people, let alone gay, lesbian, bisexual, or transgender folks. So we see that the expansion of the law brings it closer and closer to each of us. Modern marriage mostly takes place at the threshold of the divorce court. And so intimate aspects of family life come within the scrutiny of the judge. State-sanctioned gay marriage, I predict, will be another boon to marital lawyers. There's no reason to believe that gay people are any better at matrimony than heterosexuals. So everyone will get divorced, and the courts will then be required to divvy up the assets, figure out who owns the house, determine child custody and pet custody, and allocate the credit card debt. And if that debt turns out to be too severe, then there's another legal recourse. File for bankruptcy protection in federal court. If you slap your kid or kick your dog, someone will hand you a ticket and a summons to appear before the judge. If someone insults you or gives you a threatening glance, well then by all means go to court and get yourself a restraining order. Trial judges are busy issuing anti-stalking and anti-bullying decrees not just for the downtrodden and the down at heels, as was ordinarily the case in the past, but also applicable to our moneyed classes. Before I was even authorized to give this speech, I had to sign a contract with the franchise holder for the TEDtalk trademark. And in addition, legal documents were submitted to me to waive my intellectual property rights, such as they are, in these words and ideas. If you drain a swamp on your land, you can end up in court. Businesses drown in seas of regulation. And we just heard that the renewable energy police are going to be now policing where your energy comes from. Spotted owls and chickens and pigs and dogs have vestigial legal rights enforceable in court. In many countries in Western Europe and Japan, legal rights have been extended to interesting and unique trees and rock formations. Pro-life and pro-choice advocates are always at one another's throats. The only thing the opposing zealots seem to be able to agree upon is that their problems will have to be settled in federal court. If I drink too much, someone will drag me into court and commit me as an inebriate. If I am willfully eccentric, someone will put me into the psych ward on a 72-hour hold, which might morph into 6 weeks or 6 months of confinement. In this country, people of color, minorities, are controlled by antiquated drug laws that result in mass incarceration on a level equivalent to the Soviet gulags. Obviously, it's unjust, so what's the remedy? More ACLU lawyers, more lawsuits. Federal courts make school districts desegregate. Sports mascots that are politically incorrect find themselves hailed into court. White males bring reverse discrimination lawsuits, and so the carnival of litigation goes on and on. In 2000, in this country, democratic institutions collapsed to the extent that the United States Supreme Court had to pick the president. And then that president went to war, some thought in violation or contravention of the law, and then various interest groups filed lawsuits against the president and his minions, and then alleged terrorists captured on the battlefield and confined in Guantanamo Bay sued to enforce their civil rights. And so it goes. Previously sovereign territory, the autonomous family, the domains of privately held affiliation and bias, the workplace, and finally even our political institutions have all been invaded by the law, held hostage, and colonized. The courtroom has morphed from the place of last resort to the place of first recourse. Now, an empire requires an army, and some statistics will tell you this story. In 1979, when I took the bar, there were about 11,000 lawyers in this state. In 2013, Minnesota boasted 24,000 attorneys. In 1979, nationwide, there were 500,000 of us, 500,000 lawyers. There are now 1.3 million. And of course, I'm not counting armies of support staff, phalanxes of legal secretaries and paralegals and investigators and court personnel. Now, as a lawyer, I suppose you expect me to applaud these developments. But as we all know, empires not only rise, but they also can decline and fall. And the law, I submit, is in danger of collapsing under the weight of its own imperial pretensions. First, the law's unprecedented expansion implicates a paradox. Something that purports to be everything to all people often ends up by being nothing at all. And when that TV reporter called me and asked to sue the Vikings franchise, his voice carried a tone of cynical contempt. The same legal system that adjudicates slips and falls on the ice and dog bites and divorces, that same legal system should be able to manage an aggrieved ticket holder's lawsuit. So the danger of applying legal procedures too promiscuously is that those processes will be seriously discredited. The second danger that law's empire poses is more profound, I think, and more troubling. This danger arises from a limitation intrinsic to legal dispute resolution. We don't decide cases rationally. In my profession, of course, we like to conceal this troubling truth. For instance, the great English lawyer Blackstone was fond of this maxim. He proclaimed, "Law is the perfection of reason." And this motto optimistically asserts that the law solves human problems according to the dictate of reason. But let me share a secret with you. This just isn't true. In fact, Blackstone himself declared in other writing that the naked reason of man is insufficient to settle most human conflicts. At its heart, the law is mysterious and irrational. And this is because human beings are often mysterious and sometimes irrational. The law is enigmatic because all significant human dilemmas, all cases and controversies that we'll be talking about 20 years from now, 30 years from now, all of those important cases embody aspects of the tragic. And the tragic, in turn, arises from irreconcilable conflict. It is the realm of the gods, the fates, and inexplicable necessity. The Greek playwright Sophocles knew this when he wrote Antigone, the precursor to all today's courtroom dramas, a sort of 5th century BC Law and Order. In the play, Antigone is prohibited from burying the corpse of her brother who has rebelled against the regime. She does go out and bury him with her own hands in violation of the law of the city. She thinks she acts driven by a higher law. Is she morally culpable? Well, the essence of the play is the conflict of the individual and law. And it's 2,500 years now since that play was written, but it's relevant today. Consider these examples. A society, it's our society, expresses its reverence for the sanctity of human life by administering a lethal injection to kill a murderer. A husband keeps his brain-dead wife alive by court decree on a respirator so that she can give birth to their child. A freeway that will ease the commute of 100,000 people a day is built to an old neighborhood, forever destroying that community. A bus hauls small children across a city to desegregate a school, using elementary school boys and girls to recompense a crime committed 150 years ago. An anguished Christian Scientist mother refuses medical care and treatment for her sick child. All of these legal disputes embody the tragic. They involve inscrutable and insoluble human problems. And since these kinds of controversies are fundamentally insoluble, the law resolves them by using irrational ancient procedures that are more akin to divination and oracle reading than to the cold application of reason. Does the fact that a man or a woman wears a costume, that is a black judicial robe, make that person wise enough to solve these kinds of problems? Well, I have news for you. Judges aren't selected because they are the wisest or most virtuous or most brilliant people of their generation. Rather, they're ordinary men and women who have been politically chosen and then invested with the terrible power of the law. There's no reason to think that judges will decide cases intelligently or wisely. Indeed, as judges are taught, the key thing is simply to end the case, get a decision, terminate the controversy, and leave the rest to the appeals courts. And at the center of our Anglo-American system of jurisprudence is an irrational institution, the jury. Juries decide cases that they don't understand on the basis of legal principles 500 years old and inadequately explained to them. The language of the law is ritualistic and obscure, derived from Old Latin and Norman French. Certain arcane rules often prohibit jurors from hearing the very evidence that they think most relevant. These are the ancient and abstruse exclusionary rules of evidence. And a courtroom is a place where the irrational often prevails. Jurors are selected on the basis not of their wisdom or their knowledge, but on the basis of their ignorance of the law and their ignorance of the facts of the case. Their deliberations are cloaked in secrecy. And the architects of the old courthouses knew this. In those buildings, the rotundas are gathering places for the gods of sky and earth, allegorical winged figures who have been painted in murals, present to assist mere mortals in their search for justice. The portraits of famous ancestors decorate the corridors. A bullet-shredded banner carried in a battle in 1863 is displayed in a glass case. What does this have to do with the application of reason? Courthouses mimic basilicas and temples. They have secret chambers into which the ordinary public is not allowed to penetrate, and they are designed for ceremonial entrances, recessionals, and processionals. None of this, I submit, has anything to do with the cool and logical application of reason. Blackstone, the great legal theorist that I've earlier quoted, understood this when he wrote in his 1765 commentaries these words: "The mysterious science of the law is derived from ancient prejudice and divine revelation, and often obscure." Blackstone said that our legal system was an old Gothic castle full of curious relics and immemorial traditions. So, law's empire is not necessarily the domain of light and clarity. By expanding the law into all areas of life, we risk invasion by the ancient and arbitrary and tragic gloom of jurisprudence. Far from rationalizing the world, we banish common sense from our dispute resolution. We're left in law's fabulous sepulchral darkness. This is the hazard that law's empire poses. Thank you.